So what do you want?
I want to know why due procedure hasn't been followed. Okay. There were no, like for example, 2010, no demolition permit, no heritage permit, nothing. Okay, I've got this. So that's common cause. So why is this man being allowed to get away with retrospective planning, and why did he get an occupancy certificate on a building that's not built to an approved plan? When I have been saying this for years, and the on-site reality is that it isn't built to an approved plan. So where do I get my justice? That's all I'm saying.
Okay, so the question is, what is the procedure to follow?
Here's a letter written to me by my then DA councillor, Margaret Hayward, who had gone through my evidence of corruption. I had a great deal of respect for Margaret, as I still do. She was not only my councillor, but she was an ex-magistrate and also an arbitrator. She went through all my evidence that I had at that date, and she suggested I put it into some sort of report. On the 28th of April 2015, she wrote to me, "Hi Chrissy, I have read it and requested an interview with internal legal advisors to find out what they are defending. I will revert to you as soon as I have clarity. Same story with regards McCain matter. I did the same and legal advisors agreed we should not oppose this application. Yet when it went to the top, this decision was overturned. As long as you understand, I do not control the outcome. Warm regards, Marga." I gave DA PR councillor Errol Anstey the same report that I gave Margaret Hayward. There was a political fallout between him and Margaret Hayward with another matter in Bakoven. And I'd also been speaking to the Mail and Guardian as they were covering the story on the McCain matter. Basically, Errol came to my house and he met me for over an hour, and he discussed the court case with me and in fact suggested that I gave him the details so he could then approach the mayor and see if there's anything he could do. He wrote to me on the 29th of July 2015, "Hi, I suspect that the Mayor Patricia DeLille, is just going to say leave it for the courts to decide, because the lawyers have in theory already done so much work on this item, but I will give her your report, maybe it will get something done. Also, I'm not supposed to talk to anyone who has a court action against the city. I may have compromised myself here, but since I have not given you any information to date, since I don't actually have any to give, I think I am safe. Maybe it is best you do not tell me anything about the court case either. I will let you know if I get any response from the mayor's office." This email was completely disingenuous. I had met with Errol Anstey and we had discussed at great length my court matter. We had also discussed at great length Margaret Hayward and the matter with the McCains. There was a political fallout, as I've said, and Margaret Hayward was now a pariah, being treated so badly by her own party, simply for standing up for her own constituents and whistleblowing. It's very wrong from the DA, very wrong. This letter from Errol Anstey to me was written 1 year before my High Court hearing. I was being threatened. I did not know due procedure. I was a layman, but I knew something was wrong in the evidence that I was uncovering. This should have been very clear to Mayor Patricia DeLille and Helen Ziller. They had the legal mandate to intervene, but both did nothing. And this cost the taxpayer and myself a lot of money. Then Errol Anstey emailed me and said that he was going to talk to the Speaker about an intervention. I then telephoned the Speaker's office and asked for an urgent meeting, and the office said that they would call me and we would arrange to meet after the recess. The office of the Speaker then refused to meet with me after the recess as they had promised, and he refused to engage reasonably with me via email.
In some of the cases that we've had in Camp State, where the officials were clearly in the wrong, where they had allowed departures without the necessary delegations, etc., the objectors would then go to the High Court against the applicants. And for some reason, the city would then join the applicant. And we can't understand, why does the city, in the case where they were already unhelpful, where their negligence or errors had caused this dispute to go as far as the High Court, why does the city then go and become a party to this dispute between the two neighbours? And we can't understand that.
On the 15th of June 2016, I'd had a meeting with Emil Schneckenberg, who was then acting Table Bay city manager, Chris Kutsia, who was a city interface, who was dealing with this PIA application, access to information. I attended along with my attorney, Barry Barkle. I voice recorded this meeting and transcribed it for the Public Protector and the South African Police Services. I gave them very detailed minute notes, and I also provided annexures which proved fraud and forgery and the corruption in the city files with regards to the building plans. I said these minutes to Emil Schneckenberg and Chris Kutsia, and for some bizarre reason, they refused to accept them. City legal Fiona Ogle advised Ryan Menchie's Hayes attorneys not to accept the minutes of the meeting. They would give absolutely no explanation why. And I believe that Fiona Ogle, assisted by Hayes attorneys, knows about the corruption. She's highly qualified and should be able to see the corruption and perjury, fraud and forgery in the city papers for High Court Matter 15570-2013, with the first respondent being Mr. Stuart Bradbury. And Stuart Bradbury had hired a very experienced law firm, DHM, Duplessis, Hofmeyer, Milan, and an attorney called Coral Hofmeyer, who seemingly cannot read plans, and neither could his senior and junior advocate. But that's not really a good enough excuse when there is criminality involved. On the 27th of June 2016, I went to the City Forensics to report the corruption, fraud, forgery, perjury, etc. This record 57-page sequence of events started in February 2008 and it until the 29th of June 2016. Rob Strange and the City Forensics had plenty of evidence in this 57-page sequence of events alone, with the meeting notes and attachments that I'd given to Emil Schneckenberg and Chris Kutsia, the ones that they'd refused to accept, and the court record and city record. There was no need for me to give them anything else. Immediately after this meeting, I went across the road to my public protector investigator and gave her a copy of the same. I had kept in contact with Rod Strange, sending him emails of record and copying into emails to the officials because they were refusing to speak to me. It was with absolute astonishment I received an email from him on the 8th of May 2017 stating, "Dear Miss Phillips, I refer to your email dated 4th of May 2017. When Miss Hendricks and I met you, it was to obtain clarity regarding your concerns. At no time did we indicate that we would investigate same. Furthermore, and in light of the High Court finding in October 2016, and given the fact you have reported your concerns to both the South African Police Service and the Office of the Public Protector, the City has closed our file on this matter. In the event that we are contacted by either of the above agencies, we would of course provide our full cooperation." I was absolutely furious. I went to the Public Protector. I'd reported corruption, perjury, fraud, forgery, defeating the ends of justice, obstruction, abuse of power. It is absolutely extraordinary that City Forensic did nothing, and their email to me is practically a carbon copy of what Ryan Menchie's had written to me as well. I mean, how can they say the city forensics are independent? I just don't believe it.
Okay. Now this is regarding a complaint to forensics department for investigation regarding the administration of the documents.
And I also complained to these people because they've done nothing for me.
And they know for a fact we actually are Office of Law Resort.
Yeah.
Which means they can't tell you because you open a case with us, they close it.
I don't know that.
No, because we are Office of Last Resort, which means you are expected to exhaust your remedies before you come to us. So, inevitably, that means you go to them first, and then you come to us when they haven't done their job. Do you understand? So they can't tell you to close it because you came to me. It doesn't make sense.
Okay.
Okay, now obviously they must proceed with the investigation, and the second thing is the procedure regarding the handling of matters of complaints being received there needs to be a standard operating procedure like we have one when we receive and when we close. So either they must put one in place, or if they have one in place, then they must prove they have one in place and then send the investigators on training, because it must be institutionalized.
It's just that there is no way
everyone must be treated the same, basically. If it's open, you send a reference number to say it's open. If it's closed, you send a letter formally to inform you it's closed with the reference number. How are they going to keep track of their complaints?
The public protector intervened and wrote to the city insisting that they investigated my accusations. Before I play you some excerpts of that meeting with City Forensics, on the 5th of March 2018, Ryan Menchie's wrote to me, "Dear Miss Phillips, please stop sending me your baseless and conspiratorial emails. Do whatever you need to do to protect your rights with the able assistance of Mr. Varkle, and rest assured I will gladly deal with any investigative authority. I am not willing to have any further dealings with you and will not be responding to your ongoing harassment any further. I will henceforth be blocking your emails and will not be responding any further thereto." Taxing Master Bazana said that this was just deplorable behaviour, and that Mr. Menchie should never have written an email like that to me. But this is typical of the behaviour and the aggressive attitude I've had from Hayes attorneys and Fiona Ogle and Antoinette Markram, the legals. Their way of dealing with things is to bully. And quite why asserting my rights and asking for the truth is deemed as harassment will have to be discussed at the appropriate forum. This is not acceptable from a government body.
It should be free.
Should be, let me check.
Mr. Fisher, do you know anything about city procedures, or can you read plans?
I'll explain the purpose of this meeting.
No, but I just want you to answer me yes or no.
I'm
you
a
can't.
forensic investigator.
Okay.
And
Because I asked someone to be here.
no, we're not arranging someone to be
Okay.
here. We are the forensic investigators.
Okay.
If we need to understand more, we'll get that information from the relevant persons or the relevant experts.
We went through this and they...
Sorry, Mr. Fisher, it is open. So we can move that side. It's a bit bigger, so...
Does it matter? If you can't read plans, it's irrelevant. We're happy here.
Let's
fine.
Yeah.
settle in.
Okay, Mr. Fisher, so we're recording, so I think before
Yeah,
we
I'm just going to do a formal
start-
introduction now. Oh, yeah, okay.
Thank you.
If this thing wants to go on. Hold on. So the date is the 25th of January. It's 5 minutes past 1. In the interview is myself, Annette van der Waal, colleague Darren Groene, and the manager, Mr. Patrick Fisher. And we are interviewing Mrs. Phillips, and you're represented by?
Attorney Barry Varkle.
Okay. Okay, the recording has started.
Thank you. Fisher, do you know anything about city procedures, or can you read plans?
It's not all.
What I have provided. I'm so sorry. Yes. Okay. Yeah.
And I responded and I said, if there's any other documentation you want to make available to us, you're welcome to do that.
I've got 20 files like this. It's impossible.
So, but that's why I need to know what the actual complaints are. Furthermore, we're all aware there was a court case. I noticed in some of the correspondence, you were pains to state that one must not confuse the current complaints with what was dealt in the court case.
Other than the perjury and the forgery, which has got something to do with the court case. And I've made life easier for you is that I've highlighted the paragraphs where first respondent lied and also where the city officials lied.
Okay, can I just finish? Once you understand your complaints, what it is, we will go back to the court judgment because we have no intention to revisit matters dealt with by the court case. If the complaints you are raised, so I'll have to make sure that what you raised now is outside of the court case, it wasn't dealt with by the court. If you complain about irregularities on the part of officials, etc., that we will investigate and come up with findings in that regard. Okay.
Am I allowed to respond now?
Yeah, you can respond, yes?
Okay. In terms of the court matter, the city officials lied under oath. The city officials obstructed my hire applications and I believe are complicit, and I believe I have enough evidence to show beyond reasonable doubt that the city officials were complicit. I was absolutely astounded when I got the answering papers from Jaco Theron and the affidavits. I did not expect them to lie in the capacity that they did.
Is he now the city official? Yeah?
He's a city official.
Are you, for example, if you say they messed with plans, they've done this, and just listen to me. Then I'm going to say, okay, Ms. Phillips, are there documents that you want to, she's got lots of documents there, are you going to make it available to us?
The documents that I had brought with me were from the Raw 53 record and were documents from the city's own record. I kept explaining to them I didn't need to give them any documents. They had all the information. They just needed to investigate. As none of them could read plans or understand engineering or any technical issues, and Sergeant Brits from Camps Bay Police said I mustn't leave any of my reports with them, I was willing to go through them, but it was pointless in this meeting. When they hadn't provided a professional engineer and an architect and someone who understood due procedure, city procedures, which is what I asked them to be at this meeting, but they were not. So consequently, I was talking to people who didn't understand the technicalities, which was really wasting my time.
We would have to call for the file, the whole file on Earth.
I asked for that to be here.
Yeah. We have to call.
I asked for someone who could read plans to be here. I asked for someone who knew procedure to be here. You know what, Barry, let's just go.
Wait, hold on a second. So, okay.
I asked for someone who understood the process to be here, then I wouldn't have
to... the investigating process, Mrs. Phillips.
But you don't know what, you don't know procedures. The Permanent Protector wrote a letter to me saying that the city knew procedures. The city forensics have to deal with it because they know procedures. You've just told me you don't.
The point is this. All right. Let's first establish, and I was trying to ask this earlier, why are we here? What is it that you guys are doing?
Okay, what I've said,
attempting to do.
Okay, what I've said in preliminary, there was a complaint coming. Correct. So a whole host of documents.
Okay.
I was supposed to even all the documents. We went through the documents. I saw a lot of things in the documents.
So, Mr. Fisher, what did you see in the documents? I've been waiting for feedback. I've been waiting for the end of your investigation. It's now February 2020. 2 years later, what have you done?
What came out initially was the officials lied in court documents. Right? That there was a court case, people filing affidavits, responding affidavits. At the end of the day, we now get the court documents. We refer to them as lying. I have to come back to Ms. Phillips. In these documents, in what respect did they lie? She says, no, that isn't right because this plan was there. There's my supporting document. That's part of the investigation. We'll have to, at some point, then we have to confront the officials. We have to look at the entire file and look, Remember, the complainant is the one that provides the facts for us to investigate. So once I have, from the complainant's point of view,
Osram Strange, you had them a year
Peter is
ago.
online, right?
Barry and I were laughing incredulously. We couldn't believe what he was saying. I mean, this was worse than Camps Bay Police Station. And these people are supposed to be forensics. They're supposed to be investigating fraud. They just appeared to me and to Barry that they didn't know what they were doing, partly because they didn't understand procedure. I was a complete layman. You know, I mean, they had all the court documents. I found the perjury from the court documents and referred them to documents I got from city files. All they had to do was take the 2009 approved coloured drawings, compare them to the 2012 approvals, and then to the 2013 approvals. Look at the height departure letters. Look at the Tipex on all the drawings. I mean, come on. I mean, it's not rocket science.
So now I go to the court document in what respect to they lie. Now I can investigate and
well, this is where I was trying to get to earlier.
That's the first. That's only the first part.
Yes, but they justified the way the officials justified it, why they didn't have to come to sub-council, is because of this fraudulent document where the neighbours were initially asked for consent for certain minor departures, which they gave. Okay? Then a different plan is now being submitted with the consent. So they said no, because an item does not have to go to sub-council even if there's departures, if there's no objections from the So the permission from the neighbours were obtained in a fraudulent way. The plans that they submitted that they did not object to were not the same ones that had been built. If you look at the plans that the neighbours had consented to, and you look what's on the ground there now, it's totally different.
Jaco Theron's affidavit, paragraph 36. I do not know why Ms. Phillips holds the regrettable view that city officials make false statements in affidavits filed with this honourable court, and I cannot think of any reason why any official would have done so in this case. There is none, and the allegation of false evidence is denied. Here's one big fat lie that was in the court record, stating that it was confirmed that the application enjoys the approval of all the parties. In the judgment, paragraph 104, both Gonsalves and Theron denied under oath that any such communication had been made, but neither official explained how this note came to be written. Paragraph 121, Judge Bozalak states, the applicant is correct in noting that there was no satisfactory explanation by Theron, the city's decision-maker, why he had made the note concerning the approval of all parties to the 2012 building plans. This was very important, Mr. Fisher, because we had objections. It should have gone, at that point it was called the sub-council. It should have been given to my councillors. We should have been able to go through the drawings. I should have been able to assert my rights because the departures were granted unlawfully, as is clear in the court record, which all the documents are in the court record. So, Mr. Fisher, what is the city forensics conclusion?
And this is my question before you, when you didn't allow me to speak. What is it? That's what I was saying, assuming what she says is there. What is it that you guys are going to do, and what is your jurisdiction? That's what I want to know. So assuming everything she says is correct, she has the evidence to back it up, legally she's correct, we give it to you, you say yes, what is it that you're going to do against the officials, against the city? What is going to happen? Because I need to establish the direction of where we're going, because otherwise, if we're going to come to a result where you're going to say, well, you know, things happen, you know, that's the end of the story, goodbye. Then we've wasted all our time.
I've already wasted
with another investigation that's just a dead end. So if you tell me what the destination point is here, then I can tell you whether this is the appropriate legal maneuver for my client or not. I need to know that.
Can I respond?
Sure.
We investigate the complaints.
Correct.
Part of the investigation is to gather the information,
Fine.
look at review documents,
Okay.
interview people, and test what has come up against what they say.
Right.
At the end of the day, for example, if someone says you've lied in this document, and we've had cases like that before, I would say, in affidavit, Peter said A, B, C, D. Go to the documents, Peter, complainant gives her version, I assess the evidence at the end of the day. I must now then make a finding on the facts in the evidence as to whether in fact Peter lied.
No, that's fine, but I'm saying.
I did that with Rob
Okay.
Strange. I did that a year ago.
Yeah, hold on.
For example,
I did all that.
we say,
Mr. Fisher spoke down to me in a very superior manner. He spoke very, very quickly. I didn't really understand a lot of what he said because he was speaking so fast. I kind of felt he just wanted me out of there. And the fact he would only direct his conversation to Barry made me feel that as a woman, possibly I was inadequate or stupid, which was most regrettable, really.
we find, based on the evidence that that has come out of the investigation, Peter lied in his affidavit. Then we will recommend disciplinary action against Peter, etc. If it's fraud and etc., then we will recommend to SAPS as well. That is in a nutshell.
All right.
So it's a matter of gathering information, reviewing the information and documentation, testing that with the parties involved. And then make a finding and a recommendation. That's in a nutshell the process.
Fine, okay. So the men can provide all of that. Now,
I'm not providing everything. I don't trust them. I gave everything to Rob Strange. I gave everything to him.
Okay.
Okay, I gave him my 52-page affidavit to the SAPS. I asked him to investigate it. He was with another lady. He kept responding. I copied it in. I copied him in. Excuse me. I copied him into my emails. He said he was waiting for copies of the files. I've got all the correspondence from him.
Yes.
Okay.
That is, for example, can I say now? That is, for example, Mr. Rostridge is still an employee. That's why I didn't even think of giving the matter back to him.
I met 6 city forensic investigators on 2 separate occasions. I showed them fraud, I showed them forged documents, I showed them that the procedure had not been followed, and I showed them criminal activity. I sent Mr. Fisher and his team many more emails after this meeting with more evidence. I've not heard about any disciplinary procedures, and according to the SAPS, there hasn't been one criminal case opened. Which begs the question why.
if what she's saying is correct, and she has the evidence, and quite clearly just the fact that they said everything was hunky-dory, and all the approvals are there, and then when she went and did her investigations, and she showed them that the building as it stands now is not legal, and then they came back and did their supposed audit, and they came back and they said, oh yes, that part isn't legal. Then just on that alone, if we isolate that as a single instance, there's something there. Because even on their version, where they come back and they say, well, okay, right, he's got to apply for retrospective planning approval. When they've said under oath everything he did was kosher, but now all of a sudden it's not kosher. Just on that alone.
May
on
I
that
ask something,
alone, she's
If
got
you don't
something. Okay.
This is my attorney, Barry Varkle. We met with Mayor Dan Plato on the 31st of May 2019. Mayor Plato said that he would organise an independent attorney to look at my case and my reports, and if the city were found negligent, I should be compensated. When I contacted him to arrange a meeting with said attorney, he never answered the emails, and his office have now just refused to answer, and they too are stonewalling. On the 10th of February 2020, I went to see the Rate Valuation Appeal Board. I brought my attorney and I brought my engineer, Richard Whitaker, and we presented our case with regards to the unlawful building works and the fact that my house is in a state of collapse due to the removal of lateral support from the illegal building of 58. And here is the judgment.
Thank you so much, ladies and gentlemen. Phillips, thanks for bringing this matter to our attention. Thanks for the way in which the appeal has been done. Thanks, Mr. Barkley, Mr. Magolius, for your assistance. Mr. Jafta, thank you for the role that you have played. In short, the board has considered this matter, and I think we certainly see it as what we call sui generis, one of a kind. We also think, okay, if we go to the willing buyer, willing seller principle, we go into the mind of the buyer. If any of us goes there and says to Ms. Phillips, okay, we're interested in buying this property for you at 15 million, 12.5 million, 21 million, and she discloses as to what happened, shows us the videos, everything, I will simply take my suitcase, whatever, and move on to the next property that's for sale. So that's how we say the willing buyer is. We also take note that you are engaged in other legal matters. So I think something would come out of there. Probably you get and I hope that you get the decision in your favor, and some compensation would be at the order of the day. The problem that we have is that we all agree that there's major problems with the property. There is problems that, according to the experts, was brought about by the excavations. But the problem is, how do you quantify it? How do you put a value to that or amount to that problems? What is it going to cost Ms. Phillips to bring a property in the same pristine condition that it was before the excavations? 5 million, 2 million, 3 million? We don't know. There's quite a lot of stuff. I don't even think Mr. Bakoven can say that for sure. And as the board said, and I said with all respect, I think even his proposal of 15 million was done half-heartedly, not wholeheartedly. I mean, for the simple reason that he can't tell the board this is what it's going to cost to address these problems. So the board is going to take a strange decision today, a decision that is probably the first time that we're going to do this, but I will explain it. We are going to leave the valuation of the property as it was in 2015, on 9 million. In other words, and then tell the city that the moment when all the problems have been sorted, if the cracks have been completed, if everything, then the property must then be put onto a supplementary valuation. In other words, when Ms. Phillips' property is reinstated to what it was before the damage of the excavation, then it will have a value again. At this stage, I think it's impossible for you, it's impossible for Mr. Bakoven, or very difficult, or even for us to assign a value on this property. Because you don't know. You don't know whether the repairs and the maintenance and the renovations is going to be 1 million, 5 million, or 10 million. And therefore I don't want to then say come to some kind of artificial method of saying, yes, we say 11.3, the board wouldn't say on what account are we going to see is 11.3. Don't say 15 million on what account, 21 million on what account. So that's why we rule that the 2015 valuation remains as is, and the moment when the city is aware that that's been resolved, it then be put onto a supplementary valuation. Are you happy with that, Mr. Jafta? You're fine. Ms. Phillips?
Thank you so much.
It's a pleasure. Now, in doing that, I mean, is basically we look at your problem, which is a strange problem, and we think in the circumstances that probably is the best solution.
We thank the board for taking a realistic approach here. Thank you very much.
Okay, thank you so much.
The way the city of Cape Town, run by the DA, have treated me is absolutely appalling. If they had acted within their legal mandate, my house would have been safe. The illegal buildings would have been stopped. We have no law enforcement here, nothing. The public protector, it just doesn't work. The city forensics do not work. The ombudsman, both the police and the city, do not work. The inquiries are too slow, there's not enough people, and possibly they're not even educated correctly. But whatever it is, it's very wrong.
The other one is also the approval of the plans. If I understand correctly from both of you, that there was more than one set of plans.
I think at least 3 sets that we know of. Yeah. So what I then do is I take the initial consent form and I then attach it to subsequent plans that have not in fact been agreed by the neighbours. And that is a concern because that is a misrepresentation. So,